Peace Report. I'm Amy Goodman. The Supreme Court has taken the rare step of ordering a new hearing for Georgia death row prisoner Troy Anthony Davis. The nation's highest court ordered a federal district court in Georgia to, quote, receive testimony and make findings of fact as to whether evidence that could not have been obtained at the time of trial clearly establishes his innocence. In 1991, Troy Anthony Davis was convicted for the 1989 killing of an off-duty police officer named Mark McPhail. There's no physical evidence tying Davis to the crime scene, and 7 of the 9 non-police witnesses have since recanted or altered their initial testimonies. Others have implicated the prosecution's key remaining witness as the actual perpetrator of the crime. The Supreme Court decision sparked a debate between Justices John Paul Stevens and Antone Scalia. Justice Scalia, joined by Justice Clarence Thomas, called Troy Davis's factual claims a, quote, sure loser, and added that a hearing would be a, quote, fool's errand. Scalia's dissenting opinion states, quote, this court has never held that the Constitution forbids the execution of a convicted defendant who has had a full and fair trial, but is later able to convince a habeas court that he's actually innocent. Quite to the contrary, Scalia wrote, we have repeatedly left that question unresolved while expressing considerable doubt that any claim based on alleged actual innocence is constitutionally cognizable. In a separate opinion answering Scalia's dissent, Justice Stevens, joined by Justices Ruth Bader Ginsburg and Stephen Breyer, wrote, quote, the substantial risk of putting an innocent man to death clearly provides an adequate justification for holding an evidentiary hearing. Well, we'll be joined in a moment by 2 guests to discuss the significance of the Supreme Court decision. But first, I want to turn to the words of Troy Anthony Davis himself, speaking from death row. Last month, the Campaign to End the Death Penalty organized an event in support of Troy Davis at St. Mary's Church in Harlem. During the event, Troy called his sister Martina Correia on her cell phone. He was on death row. She held the phone to the microphone. He addressed the crowd.
I want all you to stand strong, continue to educate yourselves, and believe that I am Troy Davis, and I will be free, and innocence is truly matters. Thank you.
Okay. We're joined right now by Ezekiel Edwards, a staff attorney at the Innocence Project. Welcome to Democracy Now!
Nice to be here. Thank you.
Talk about this extremely rare move, close to 50 years or perhaps more than 50 years, the Supreme Court hasn't made a ruling like this?
Yes, the only option left for Troy Davis at this point, after losing in Georgia Supreme Court and losing at the 11th Circuit, was to appeal directly to the Supreme Court and asking it basically in a move under its Rule 20 original habeas jurisdiction, which means basically asking the Supreme Court to find that he is actually being held unconstitutionally. So he made a direct appeal to the Supreme Court. According to the Supreme Court's own rules, that has to be used very sparingly and only in exceptional circumstances. And luckily, 6 of the 8 justices recognized that in this case, in Troy Davis's case, it was indeed an exceptional circumstance that necessitated them to act.
Sonia Sotomayor, while now a new Associate Justice of the Court, did not rule in this case.
No, it was only it was 8 of the 9 because she's just arriving. So Scalia and Thomas were the only 2 who decided that the evidence that Troy could and wanted to put forward would not save him from execution.
In a few moments, we're going to go through the details of the case with Amnesty International and then with Troy Anthony Davis's sister, who has been championing his cause for a long time, and his 15-year-old nephew, who is a budding human rights activist. Going through the significance of 7 of the 9 non-police witnesses recanting or altering their testimony.
Well, this is clearly, to me, and certainly to the 6 of the 8 justices, a compelling case of innocence that Troy Davis has put forward. What's remarkable is, despite the fact that 7 of the 9, as you said, witnesses at trial have recanted, despite the fact that there is also new evidence pointing to the actual killer, Red Coles, who in fact was the person to point the finger at Davis back in 1989, no court before this has ever conducted a hearing on this new new evidence. There is compelling evidence here. The Supreme Court recognizes that, and they have finally said that a district court must take testimony, which no other court has yet done. Disturbingly, Justices Scalia and Thomas were willing to go to bed at night without having any court heard that evidence, live testimony, and gone to bed knowing that without hearing it, Troy Davis would nonetheless be executed.
Now, I want to go back to that quote of Antone and Scalia. The court has never held that the Constitution forbids the execution of a convicted defendant who has had a full and fair trial, but is later able to convince a habeas court that he's actually innocent. Quite to the contrary, we've repeatedly left that question unresolved while expressing considerable doubt that any claim based on alleged actual innocence is constitutionally cognizable. What does that mean?
Well, the only thing that Scalia has right there is that it's true that the Supreme Court has never actually held that it would be unconstitutional to execute an innocent person. But one point is that a number of justices, in their opinions in the past, have said that were that to be the issue we were faced with, it would unquestionably be unconstitutional. So very few justices have any problem saying that it would be. What's quite disturbing is that Justice Scalia and Justice Thomas clearly take the position that even if a prisoner were able to demonstrably prove that they were innocent, and beyond any scintilla of a doubt, he would nonetheless say that there's nothing that the Supreme Court or federal courts could do, and that that person nonetheless would be executed, and that that wouldn't violate the Constitution. I would like to say that that is a minority position, thankfully, on the court.
You were with the Innocence Project. How many cases have been overturned both on death row and those who are not on death row?
Through the use of DNA post-conviction testing, we've been able to exonerate 241 people so far. 17 of those were on death row. This is significant because the problems in our criminal justice system with forensic science, with eyewitness identification, and with wrongful convictions are incredibly pressing, and we've been able to demonstrate that through DNA testing. But this is really just the tip of the iceberg, the DNA cases. Most cases don't involve DNA evidence. It's been lost, it was never there, they can't find it. And so this is really just a window into what could be thousands and thousands and thousands of people who are in prison on death row for crimes they didn't commit. So how the Supreme Court looks at petitioners' quests to prove their innocence is critical. And yet again, I'm happy to say that 6 of the justices recognized that in Troy Anthony Davis's case, where DNA was not present, but there was significant eyewitness problems, he should have his day in court to prove his innocence. And
so just to see how this will go down now, a federal court judge will look at Troy Anthony Davis's case, look at the evidence. Yes, and then what happens?
Well, they will take testimony, and again, the first time that any court has taken testimony on evidence of innocence before deciding to execute.
Meaning bring up the people who've recanted their testimony.
That's right. They will give live testimony. They will give direct examination. They've been cross-examined. It's also an opportunity for his lawyers to present evidence of eyewitness unreliability, of scientific research over the last 30 years that has shown how fragile memory is and how many wrongful convictions are based on mistaken ID, and basically paint an entire picture based on recanting witnesses, new evidence of innocence pointing to the actual killer, eyewitness identification problems, to establish that, in fact, Troy Davis was not the shooter in this case.
Now, he, the judge, or she, the judge, cannot exonerate Troy Davis right at that moment. Is that right? That would determine whether there would be a new trial?
Yes, they can. They could grant Troy Davis a new trial, but in fact, if they grant him a habeas hearing and say that he's being held unconstitutionally, I believe that they would actually have the power to release him. Now, Justice Scalia and Justice Stevens disagree on what the district court can and can't do, even if they were to credit all the evidence of innocence. But Justice Stevens' position is that there's many things that the district court can do to give Troy Davis relief.
And if the judge rules that the evidence is not good enough, the lawyers for Troy Davis could appeal again to the Supreme Court?
Correct.
Ezekiel Edwards, I want to thank you for being with us, staff attorney with the Innocence Project. This is Democracy Now! When we come back, we'll hear what happened on that night exactly 20 years ago, or a description of the events surrounding the killing of the police officer and the arrest and the conviction of Troy Anthony Davis. And then we'll speak with Troy Anthony Davis's biggest advocates, his sister, Martina Correia, who's fighting for her own life, has stage 4 breast cancer, as well as her brothers, and his nephew, who's just turned 15 years old and just addressed 5,000 people at the centennial convention of the NAACP. Stay with us.